Hi, my name is Andrew Meinzer of Meinzer Law Firm. This video is the fifth in a series about conservatorship court proceedings in California. In the prior videos, we covered who might need a conservatorship court proceeding, the three types of conservatorship proceedings, the two aspects of each of them, some of the court procedures in general, and the process of having the court put someone in charge of another person through a conservatorship court proceeding. In this video, I'm going to discuss with you your responsibilities as conservator now that the court has put you in charge. One of your first responsibilities is to mail a notice to the conservatee informing him of your appointment as conservator. If this is a conservatorship of the person providing you with authority over medical and personal affairs, then you also need to prepare a plan for providing care to the conservatee. Mail that plan to his relatives and file it with the court. If you're conservator of the estate in charge of assets and income, then after the court generates the two documents showing that you are having authority as conservator, you'll use those two documents to change the ownership of all of the conservatee's assets to your name as the person in charge as conservator of the conservatorship proceeding. And as conservator of the estate, you also need to file an inventory and account petitions with the court. The inventory lists all of the assets of the conservatee that will be subject to this court proceeding, and it indicates the value of those assets as of the date when the court created the conservatorship by appointing you as conservator. And also in some counties, the inventory needs to list the conservatee's annual benefits income like Social Security. If there are assets other than cash and personal effects such as clothing and furniture, then a person called a probate referee will need to provide the value of those assets on the inventory. The probate referee charges a fee for the service, and you can pay it from the assets of the conservatee. We need to go to court at the end of the first year of the conservatorship. We need to file another petition with the court, and again, it will be set for hearing before a judge. This petition is called an accounting or an account petition. An account petition shows precisely how you managed all of the assets during the first year. Then after that first account petition, we generally need to go back to court with an account petition every other year as long as the conservatee is alive. These accounts are extremely detailed and they need to be in the format required by California law, which is a pretty unique accounting format. They also need to be accurate to the penny. And to help the court verify the accounts are accurate, we need to file with the court originals of bank account statements, statements pertaining to other financial accounts, statements of any skilled nursing facility or residential care facility, and escrow closing statements if real property is sold. It's possible to have the court waive that account petition requirement sometimes, which I'll discuss in the next video in this series. And this accounting and inventory requirement, by the way, again, only applies as conservator of the estate. As conservator, you're entitled to be paid fees from the assets of the conservatee. As your attorney, we are also entitled to be paid from the assets of the conservatee. You may not pay either of us from those assets without prior approval from the court. To minimize our total fees, we normally request court approval of these fees through these account petitions since we're already going to court anyway. Again, in some cases, we can have the court waive a lot of these requirements, as you'll see in the next video.